please the court, my name is Guy Burns. I'm with the Johnson Pope Law Firm here for the appellant, accompanied by Richard Pettit of the Pettit-Worrell firm, who was co-counsel in this case. This case involves a dispute over attorney's fees out of a condemnation case. While the fee agreement that was drafted by Mr. Rush in this case had language dealing with arbitration, the appellants contend that the lower court erred in granting an order compelling arbitration for three reasons. One, the arbitration language in Mr. Rush's fee agreement contains an unenforceable arbitration agreement. Two, the court did not allow a robust or reasonable summary proceeding to the appellants, even though one was requested. And number three, Mr. Rush, by his conduct in proceeding with the collection of his attorney's fees in a court proceeding that was parallel to and transferred to the same court as this proceeding, waived his right to proceed in arbitration. On the first point, is there an enforceable arbitration agreement? In order to have an enforceable arbitration agreement, the cases are clear that the agreement must set forth the form and procedure for the arbitration. It must set forth the number of arbitrators. It must state how the arbitrators are to be selected and what issues are to be decided. The agreement in this case is missing the first three. The agreement does not incorporate by reference the Florida Arbitration Code. There are several cases cited where the court has held that by citing the code that the judge can, quote, fill in the gaps allowed by the code in order to provide other missing essential terms.
And that's what I wanted to ask you, Mr. Burns, because the cases that was cited in your brief, they're all different because they make reference to a general arbitration. Here, if you look at the agreement, it specifies either the Florida Bar Arbitration Program or the American Arbitration Association. And each of those have, let's just use the American Arbitration Association. That by itself delineates exactly how many arbitrators and the method. So why isn't Appley's argument appropriate that their fee agreement complies because it specifically delineated either of these two programs?
For a couple of reasons. First, what the agreement says is that the matter would be arbitrated before the Florida Arbitration Program, which does not have subject matter jurisdiction over this contest because the Florida Arbitration Program is limited to matters where the parties are simply debating the amount of the fee. There's no, you can't have any claims for malpractice, you can't have any claims for misfeasance, you can't have any claims for other aspects of the case which have been raised by Mr. Rush and in this particular case.
Although maybe not crystal clear, when I go to the next paragraph, though, it appears to add an option. I can do the Florida Bar Arbitration Program, or I can go to another arbitration administrator, such as the AAA.
And what the contract says, or some other comparable arbitration program, such as the AAA.
Comparable to the Florida program.
And the AAA program is not comparable to the AAA for two reasons that I can think of off the top of my head. First, it's not free, and the Florida Bar program is free. And secondly, it does not have the same limitations of subject matter jurisdiction that are the Florida Bar program. So it is a different program, but it's not even an agreed program. It says to a comparable program, such as. And the one cited as comparable is, in fact, not comparable. So the agreement is not, quote, an enforceable agreement, which is the statutory test, because it is missing two of the essential terms. One is the form and procedure. And interestingly enough, the court, recognizing that when it enters the order, says that the matter is going to be arbitrated pursuant to the Florida Rules of Civil Procedure. And arbitration programs, such as AAA or others, have their own rules of procedure. Those are not the Florida Rules of Procedure. So the judge is trying to fill in these blanks that are missing from the agreement, and the Florida Arbitration Code doesn't allow that blank to be filled in. The only blank that's missing in these three elements that are missing that it can be filled in is the method of the appointment of the arbitrators. The new arbitration code allows that, but it does not, on the other instance, allow the judge to say how many arbitrators will be selected. The judge in her order seems to indicate that what she's going to do is to have a multiple number of arbitrators. She doesn't say 3, but she clearly is talking plural. The parties will agree on the quote arbitrators, and if they can't agree on the arbitrators, she will appoint the arbitrators. The agreement prepared by Mr. Rush does not say whether there's going to be 1 or 3 or 5 or how many, and so under the case law, the number of arbitrators is an essential element to be agreed upon, and it is missing from this particular contract. So at least 2 of the 4 elements required, that is the procedure for the arbitration in the form and the number of arbitrators, is missing. I'd like to move on to the second reason why this case should be reversed, and that is that the court, as required by the arbitration code, is required to conduct a summary procedure when an objection to the arbitration is raised.
But you're talking about the need for an evidentiary hearing, correct?
A summary procedure certainly could include an evidentiary hearing.
It would not, because going to your first argument, if we're talking about missing terms, whether you have a contract or not is a question of law. So
that is correct.
So you probably would not need testimony if we're talking about a defective contract.
But, Your Honor, that was not the only issue raised at the hearing. The first words out of counsel's mouth for the appellants at the hearing was to say that they had received this lawsuit not long ago. It was filed on August the 6th. They were at a hearing on September 13th, and they said, we seek a delay in the hearing until a later date to allow us to conduct some limited discovery and for an evidentiary hearing, which I believe we are entitled to. And that is on page 4 of a long transcript of that hearing.
But what is the judge going to do at an evidentiary hearing? I mean, this is to resolve factual disputes, right? An evidentiary hearing?
Certainly.
And was there any objection to the making of the arbitration agreement or with the fee agreement with the arbitration clause in it?
That was certainly raised in the objections. We wanted to go into that.
Any affidavits filed in that respect?
And as an example, I will tell you, Mr. Rush, in his briefing papers in this case, says that he's representing to the court North Park's managing member, Todd Taylor, had the opportunity to review the agreement. That would be subject to some discovery. He was advised to seek independent counsel.
But was there an objection made that he didn't have the opportunity?
He's raising this in his brief before this court. He's saying that no summary proceeding was necessary because of these facts. Those facts are asserted in a brief in this case, having not been challenged before.
But the question is, what was requested before the court? You want some discovery. What is the discovery that would have been undertaken that would have raised questions as to the making of the arbitration agreement or to the waiver of the ability to arbitrate?
Right. And what was asked, and there were 4 references to we want to take some discovery in the hearing. I have had one of them here in my notebook that it says, Ms. Porter says, or Mr. Porter says, we received this lawsuit. We're asking the court to dismiss it or at least delay the hearing of the petition until a later date to allow us some time to conduct some limited discovery and then set it for an evidentiary hearing, which we believe the law entitles us to do.
Discovery about what?
About the making of this contract.
Okay.
And the judge, in a hearing that lasted a half an hour, which contained other motions, blew past this issue and just said, we're going to go ahead and arbitrate this, and didn't allow any inquiry into this matter. We have a lawyer who's prepared a contract. There's a disadvantage in the bargaining power. The lawyer presents the contract to the client, and it's signed, and we have a right to go into that entire matter. The contract did provide the required language that the client should seek independent advice.
about the about the arbitration proceeding, did it not?
It does, but then the brief that they have filed states that Mr. Taylor was advised to seek independent counsel and decided to sign the arbitration agreement. What evidence do they have that he was advised? There's language in the agreement, but was there any discussion about that?
The burden's going to be on your client to challenge the making of the agreement.
And we'd like to have a
not evidence from Mr. Rush.
And we'd like to have a summary. We'd like to have an opportunity to take some limited discovery and have a summary proceeding to address those points.
Okay.
And that was denied. And finally, on the third point, there has been a waiver because Mr. Rush, before he filed this case seeking arbitration in August of 2018, had filed, I believe, at least 7 separate motions with the condemnation court, which had been, while not consolidated with this case, had been transferred to the same judge, seeking an award of his attorney's fees. And
so was it a fee request on his behalf, or was it a fee request in the condemnation case on his client's behalf?
It was a request on his behalf seeking to be paid fees from the condemnation case. And the judge finally said, listen, we'll give you notice, you'll be on the certificate of service, and anything dealing with this case or these fees you'll get notice of and you'll have an opportunity to be heard. But he was coming into the court seeking the court to set up a procedure to protect his fee. That's what he was concerned with. He was no longer counsel for the client. He was trying to protect and seek his fee.
But the fees in the DOT case were to come from the DOT, not the client, correct?
That fee would be paid by the DOT. But his measure, in the contract itself, he says that's going to be the exclusive source of his recovery. Then later in the contract, he says that if he's fired, there could be a quantum merit discussion.
But how is it a waiver to argue in the condemnation case where he's trying to preserve his fees with the DOT? How is that a waiver in a separate case?
But at the very least, he's seeking fees in 2 places, and the measure of his damage are his fees, whatever he contends is the fair fee or the statutorily provided fee or the allocation of the fee. This case is about his fee.
But he could not compel DOT to arbitrate a fee.
No, he couldn't, but he could request that the court allocate either all or part of that fee to him. And at the same time, he wants to arbitrate over that same fee with my client in an arbitration proceeding. At the very least, he ought to exhaust that remedy first, and if he believes that after exhausting that remedy, there is some remaining amount that is owed and a legitimate dispute arises, then perhaps seek arbitration, but he is simultaneously seeking his fee from 2 different forms.
Are you saying that's inconsistent with the contract?
I'm saying it's not only inconsistent with the contract, it is inconsistent with being able to, it's inconsistent with a provision that requires him not to have waived by proceeding in another manner to collect the same damages he's going for in arbitration.
But aren't those cases, Mr. Burns, the ones that you cited to, that depicts that, and typically you have one lawsuit, and in that one lawsuit, that's when you have all these case law develop as to waiver. When you have an attorney, even though there's an arbitration proceeding, they go forward, file a motion for fees, participate in going forward for fees, and as a result of those factual matters, that's where our courts have indicated there's a waiver. But here it's a little bit different. You're dealing with, to follow up, it's DOT. There's a preservation, wants to make sure that that's at least your client to pursue the fees there. And he also wants to say, by the way, this is for my client, but I don't want to be left out. So trying to mention that, and what he did was appropriately file a separate lawsuit in order to proceed with arbitration. So I guess what I'm trying to say, I see the facts here a bit different from the case law that you supported in your brief.
Yeah, I believe that he is either waived or, at the very minimum, he should be required to exhaust the remedies he has already started going down that road by filing 7 motions with the court before he filed for this arbitration, because I think that's clearly trying to get the same remedy from
But then
2 different
couldn't a stay
locations.
have been sought?
Pardon me?
Couldn't he have sought a stay? A stay?
Yes, and we did.
Mr. Burns, you're at 15 minutes. I don't know if you want to reserve some rebuttal
I
time.
did not reserve any time, but I would ask if there's any further questions, I'll take them now, and if not, I will reserve the balance.
Fine.
Thank you.
Thank you, Mr. Burns. Mr. Cisco?
May it please the court, Dale Cisco on behalf of the Brian Rush and his law firms, Woodlief and Rush and Brian Rush, PA, and good morning. In this case, the trial court did not err in entering the order compelling arbitration. A review of the transcript of the hearing shows that the moving party, in this case it was filed as a motion to dismiss initially, but on the same docket was a nearly identical motion by Mr. Rush to compel arbitration pursuant to the terms of the fee agreement. So the issues, although they were raised initially under the motion to dismiss, were the identical issues that would have had to have been determined by the court on Mr. Rush's motion to compel arbitration in that proceeding.
Can I have you focus in on an issue that Mr. Burns raised? And that issue is the request for an evidentiary hearing. The request was made for a continuance in order for them to pursue whether or not this is a valid contract. Can I have you address that?
Sure. I wasn't involved, obviously, in the hearing, but it appears that the petition for arbitration was filed in early August, and this hearing was originally scheduled for August the 27th, and then continued to September the 13th, following a motion by the North Park defendants to have their motion to dismiss heard before the motion to compel arbitration pursuant to the terms of the retainer agreement. So the notice for this hearing on the 13th put the motion to dismiss first pursuant to what the court had directed, and then the remainder of the motions that were on the calendar. And so, I think that the appellants had the opportunity to do a couple things if they thought that an evidentiary hearing was necessary or that there was a factual issue. And that was noted by the panel. There were no proffers of testimony from Mr. Taylor or anyone else to demonstrate that he didn't understand the agreement, he wasn't competent to execute it, he didn't have the authority of the parties. That wasn't raised in any proffer, by an affidavit, by any mechanism whatsoever. In fact, to answer Judge LaRose the question that you asked in the initial argument was, what was asked for at the hearing? The only discovery that was asked for at the hearing was a request for a 2-hour evidentiary hearing without saying why, except they wanted to take the deposition of Mr. Rush. But it didn't say, I want to take the deposition of Mr. Rush for any particular purpose. So in terms of your question regarding the continuance, I think that all of the things became ripe at the same time, and that's why they were all before the court on the 13th of September when this hearing was held.
Mr. Cisco, could you give me your view on the scope of the jurisdiction of the Florida Bar Arbitration Program?
Sure. I would agree that the Florida Bar Arbitration Program does have limited jurisdiction to review fee agreements. And I think if you look at the arbitration provision or the dispute resolution provision that's in the engagement letter, it's primarily intended, I think, it's it seems to me to be pretty obvious, it's to protect his fee. He spent 4 years actively litigating this case, only to be terminated after that period of time, and there's a provision in the agreement for if he's terminated, then the responsibility for the fees may become the obligation of his clients, the North Park parties. And because the arbitration agreement also references AAA or a similar organization, I think it provides for the opportunity to use organizations other than the Florida Bar if it becomes impossible for the bar to resolve all the disputes that would be subject to an arbitration.
Well, help my concern, because if there's a limited scope of the arbitration program, I'm having trouble understanding how some other comparable program, be it AAA or JAMS or whatever, wouldn't that alternative have to be similar to the arbitration program with a very limited focus of its jurisdiction?
I don't believe so, Judge. I think that that there are contemplated by the dispute resolution provision in the agreement the possibility that there will be disputes other than fee disputes that come up, because the provision is extremely broad. It covers anything related to the relationship between the attorney and the client. So the appellant's arguments are with regard to, and I guess I'll start with waiver because it's it's where you finished and it's the easiest, I think, to deal with. And that is that the representation or the request is being made that you find that Mr. Rush and his law firms waived arbitration by preserving the client's right to fees in the eminent domain action. And I think the questions that were asked were correct in that the case law establishes that if he takes an action that's inconsistent with arbitration in litigation where the parties could be subject to that arbitration contract, then that might be considered to be a waiver. But here, the motions that were filed were motions to protect the statutory fees that the client was entitled to from the Florida Department of Transportation, and as noted, they could not be compelled to arbitrate pursuant to the terms of the agreement that was the subject of the motion. So the filing of the motions, if you look at the timing of them, they were done both before Mr. Rush's termination and within the 30 days after, as he's withdrawing from the case as required under the rules, and he has 30 days to protect those claims for attorney's fees. So, I think it's clear that that's the reason why he's doing it. Now, within a couple weeks of filing the last of those motions, he's now filed a petition for arbitration under the terms of his agreement. So the filing of those motions, I don't believe is a waiver because it's not inconsistent with the rights, his rights under the terms of the contract. The other issues that were raised relate to whether or not this agreement was enforceable and whether or not an evidentiary hearing of some kind was required. I believe that because of the way that this agreement was drafted, in particular having the very conspicuous Florida Bar mandated notice to the client on the first page of the agreement, advising them that this agreement contains a provision for arbitration and that you may want to get the advice of another lawyer before you execute the agreement because you're waiving significant rights. And I think looking at the agreement as a whole, the arguments in the brief that Mr. Taylor had the opportunity to read the agreement, that he had the opportunity to consult counsel, are logical inferences from the language of the agreement itself. Right above his signature it says, "Read carefully before signing." The dispute resolution program is very detailed, and I would suggest to you that Mr. Taylor, as the managing member of a development company, is likely not an unsophisticated individual in terms of these agreements. And again, there was no evidence presented or suggested to show that he was not competent, which is the way that this usually comes up in arbitration issues, particularly in nursing home litigation, is was the resident competent to understand the terms of the agreement, or if they didn't sign it, did the person who signed it for them have the proper authority to execute the agreement? There was no allegation like that here. So under the terms of this agreement, and when you look at the Florida's revised arbitration code, this is clearly subject to the new code. It's a September 2014 agreement. The new code applies to contracts entered into after July 1 of 2013. That provision provides for an inference to or a preference for arbitration. Both the Florida courts and the federal courts have determined that all doubts regarding arbitration should be resolved in favor of arbitration rather than against it. That's what I believe the trial judge did in this case. I think she looked at the terms of the agreement and looked at what was presented by the appellants and determined that there was no need for an evidentiary hearing, and that she resolved only issues as to the legal sufficiency of the document and the agreement, and compelled arbitration accordingly. So what I would ask is that the court enter an order affirming the order of the trial court, and I'd otherwise rely on the writings unless the court has any further questions for me.
Thank you, Mr. Sisko.
Thank you.
Mr. Burns?
Thank you, Your Honor. I'll try to take less than the 5 minutes, unless you have questions. I would like to point out to the court on the summary procedure that was denied that the Fourth District has spoken directly on the issue in the American Management Services case we cited in our briefings. That's a 2016 case. The court says when a party seeks to compel arbitration and the other party opposes the motion, the trial court must first determine whether there is disputed factual issues regarding the making of the arbitration agreement. A disputed factual issue can be established by argument of counsel at the hearing, by the filing of a written response in opposition to the arbitration, or by filing affidavits or other documents. If the court determines there is a substantial disputed issue, then it must set an expedited evidentiary hearing. In this case, the order of the court made no such finding that there were no material issues. It made no finding one way or the other. It just said the motion to compel arbitration is granted. And so there was no attempt by the court, in spite of the repeated request, both in written motion and in verbal presentation before the court, to set the case for a hearing and to allow some limited discovery. As to the waiver issue, the point continues to be raised that Mr. Rush was just merely trying to protect the client's position. These motions were filed in part after he was the client's lawyer, and his engagement agreement with the client says that his fees are going to be limited to those paid by the state of Florida Department of Transportation, and he cites even 2 statutes for the attorney's fees. So while he may say, I was trying to protect the client's rights to attorney's fees, he had, by agreement, had entered into an agreement that that was going to be the source of his fees, and he was trying to protect his own fees and collect his own fees. And while nominally those fees may have flowed through the client, he was trying to protect his own self-interest. Thank you.
Thank you, Mr.
Thank you
Burns.
both.
Thank you both.